Prohibition of Smoking and Protection of Non-Smokers Health Ordinance, 2002. Purpose: to provide for the prohibition of smoking and other tobacco uses in places of public work or use and public service vehicles, and to protect the health of non-smokers. Introduction. Whereas smoking and other tobacco uses is posing a serious threat to the health of people and the environment, it is expedient to provide for prohibition of smoking and other tobacco uses in places of public work or use and in public service vehicles, and to protect the health of non-smokers and for matters connected therewith or ancillary thereto. Definitions. Place of public work or use means any place declared as such under Section 3, and includes auditoriums, buildings, health institutions, amusement centers, restaurants, public offices, court buildings, cinema halls, conference or seminar halls, eating houses, hotel lounges, other waiting lounges, libraries, bus stations or stands, sports stadiums, educational institutions, libraries, and the like, which are visited by general public, but does not include any open place. Smoking means smoking of tobacco in any form, whether in the form of cigarettes, cigars or otherwise, with the aid of a pipe, wrapper, or any other instrument. Powers to declare no smoking places of public work of use. As soon as may be after the commencement of this ordinance, the federal government may from time to time, by notification in the official gazette, declare any place of public work or use to be a no smoking and no tobacco use place for the purposes of this ordinance. Power to authorize. The federal government may, by notification in the official gazette, authorize one or more persons who shall be competent to act under this ordinance. Prohibition of smoking and other tobacco. No person shall smoke or use tobacco in any other form, in any place of public work or use. The federal government may, however, issue guidelines for permitting designated smoking areas in premises or places where adequate arrangements are made to protect the health of non-smokers. Prohibition of smoking in public service vehicles, without prejudice to the provisions of the Provincial Motor Vehicles Ordinance, 1965 W.P. Ordinance 19 of 1965. No person shall smoke or use tobacco in any other form in a public service vehicle. Prohibition on advertisement of cigarettes, etc., notwithstanding anything contained in any other law, for the time being in force. No person or company shall advertise tobacco and tobacco product on any media or in any place, in any public service vehicle, if such advertisement is not in accordance with guidelines prescribed for this purpose by a committee which the federal government may, by notification in the official gazette, constitute. Prohibition of sale of cigarettes, etc., to minors. No person shall sell cigarettes, or any other smoking substance, to any person who is below the age of 18 years. Prohibition of storage, sale, and distribution of cigarettes, etc., in the immediate vicinity of educational institutions. No person shall himself, or by any person on his behalf, store, sell, or distribute cigarettes or any other smoking substance, or any other tobacco product within 50 meters from any college, school, or educational institution. Display and exhibition of board. The owner or manager or in charge of the affairs of every place of public work or use shall display and exhibit a board at each conspicuous place in and outside the premises visited or used by general public, prominently stating that the place is a no smoking zone and that smoking is an offense. Penalties. Any person who contravenes the provisions, I Section 5, 6 or 10, shall be punishable with fine, which may extend to 1,000 rupees, and in case of second or subsequent offense, shall be punishable with a fine, which shall not be less than 1,000 rupees, and may extend to 100,000 rupees, and 3B12. Section 78 or 9 shall be punishable with fine, which may extend to 5,000 rupees, and in case of second or subsequent offense, shall be punishable with imprisonment, which may extend to 3 months, or with a fine which shall not be less than 100,000 rupees, or with both. 1. Removing violators from public places. Any authorized officer or a police officer, sub-inspector, or higher rank can eject any person from a public place if they are breaking the rules of this law. Government's power to delegate authority. The federal government can allow other officers or provincial authorities to enforce this law. This law is in addition to other laws. This law does not cancel any other existing laws, it works alongside them. Court procedures for trial. Available offenses. The accused has the right to bail, can be released after fulfilling bail conditions. Be cognizable offenses. Police can arrest without a warrant. Only a first-class magistrate, a senior-level judicial officer, can hear these cases. See summary trial. Fast-track process. The magistrate can decide the case quickly. Summary trial, instead of a lengthy trial, follows the summary trial procedure under the Code of Criminal Procedure (PC) 1898. Desentencing powers. The magistrate can impose any punishment allowed under ordinance: fines, imprisonment, or both. Recommendations for better enforcement: increase fines and strict penalties, dedicated enforcement teams, public awareness drives, stronger provincial coordination. Fast-track. The Data Protection Bill to regulate tobacco companies' influence. Final verdict. While Pakistan has anti-smoking laws, but without stricter penalties, better enforcement, and public education, the Protection of Non-Smokers Ordinance 2002 will continue to be ignored. Strong political will and policy reforms are needed to make public spaces truly smoke-free.